All right, let's talk about limitations imposed on the testator. Pretty much, testator has liberal discretion in the disposition of wealth during lifetime or at death, but the law, for public policy reasons, imposes some limitations. And we're going to look at the elective share in this class, but we're also looking at what's called a pretermitted heir, which is it's a forgotten child. All right. For a review, we look at the revocation statute and we understand physical act revocation, which is intent plus the act. There is also a way to bring back, say, never mind, conditional revocation. If you do a physical act revocation on a will and you try to update it, keeping in mind you cannot make the update without going through the requisite formalities. And so sometimes the facts support that the testator would have preferred the unrevoked will. So it's sort of the concept of bring back, never mind on the revocation if what I updated it to cannot be enforceable. Subsequent instrument wills should include a revocation provision. I hereby revoke my prior will. That is effective immediately. So if you prepare a valid will revoking an earlier will and then physical act revocation revoke the revoking will, it does not bring back the will it revoked. Implied revocation is when there is no express revocation, but the two wills are so inconsistent that they cannot be read together. If the second will has a residual clause, then those two wills cannot be read together. Operation of law, automatic. If it's a divorce, then all provisions relating to the spouse will be revoked. The UPC has a little bit broader of a statute and revokes provisions to relatives of the spouse as well. All right, so let's talk about the limitations. We're going to be primarily looking at the elective share and then next class looking at the pretermitted heir. The elective share is something that a spouse, someone who is married to the decedent at death, has a right to elect, but they actually have to take an action to elect within a timely period. There are broadly two approaches. The traditional approach, which came from the replacement of dower and curtsy rights from common law, is a percentage of probate. But as individuals began to own assets outside of probate, the UPC in 1969 realized that it was necessary to have a broader statute. And the UPC model was enacted in 69. And Maryland for many years followed the traditional, but has in 2020 updated its statute to something a little different than the augmented estate, but allegedly uses some of that terminology. All right, let's talk about it. Why do we need protection? We only need protection in common law property systems where each spouse has the right to accumulate and title property in his or her name. The idea is that we had a breadwinner spouse and a caretaker spouse, and the caretaker was home and did not have the ability to accumulate and title property in his or her name, while the breadwinner spouse was out working, got the paycheck, put it in his or her sole name. So we needed a way of protecting the caretaker spouse, and that's where they came up with this elective share. Community property jurisdictions, however, no matter who is the breadwinner, when property is accumulated during marriage, it becomes what's called marital property, in which case each party to that marriage is entitled to a 1/2. So they don't need the protection like the common law jurisdictions. Maryland is obviously a common law property system. So limitation, we have to think about who is a spouse. Just because somebody separates doesn't mean that they aren't a spouse. They're a spouse until the judgment of divorce, and they have to do something to elect. Schempp v. Huff is the Maryland case that makes us look at the importance of the elective share. In that case, there was a joint will. The spouse, Clara, had died, and the testator, Lester, did not prepare a new will, and his second wife was able to elect against the joint will that he had with Clara. And the court allowed the elective share to trump the contract rights of the beneficiaries under the joint will. Let's take a little bit of a look at waiver. Many parties sign waivers or contracts in which they give up the right to elect or intestate share. Other protections such as waste, violation of public policy, you cannot prohibit marriage or encourage divorce in order for someone to inherit. And believe it or not, the rule against perpetuities is another limitation that we impose upon the testator. So the contract gettings case, look at what are the requirements of the marital agreement. Full and fair disclosure is important. Some of the marital agreements that might be discussed, prenuptial, postnuptial, separation agreement, they are all just simply contracts in which parties waive their right to take a combination of the elective and or intestate share. Let's look at these two approaches in the calculation. Traditional, very easy, what Maryland followed up until 2020. It is simply a percentage, either a third or a half of probate. Obviously, since there are multiple assets that are held in a non-probate format, we've got to have some common law version of looking how do we get to those other assets. And that's where we come up with what I call a common law supplement. The augmented estate pools all of the assets of both parties with a much more complicated calculation. Probate, non-probate going to somebody other than the surviving spouse, non-probate going to the spouse, and the spouse's own property. The spouse's property is going into that calculation. So it's taking a look at all of the assets of both parties, multiplying it times a percentage based on years of marriage, and then the spouse is entitled to half of that. So that calculates the amount. Then we have to look at what did the spouse get. In the traditional, they're only going to be considering, was there anything given to the spouse under the will? In the augmented estate, we look in multiple places to see what the spouse got. We look at probate, we look at non-probate spouse, and the marital portion of the spouse's own property. Is there a right to elect? If the elective share amount exceeds the right to elect, yes. If not, no. And then finally, where does it come from? Again, traditional, very straightforward, all probate. We're going to apply the rules of abatement. What's left in augmented estate? There might be some remaining probate and mostly the non-probate others, and they will contribute proportionately. Sullivan is a traditional elective share case. We look at what the court tried to create in terms of a common law modification for future spouses. It doesn't help the spouse in that case. Look at the arguments that were made by the spouse to get that revocable trust brought back into the estate for purposes of calculating her elective share. Nell v. Price was a Maryland case that came along. Again, we have a spouse making a successful argument to bring back a non-probate asset, and that situation was a life estate deed with a remainder interest going to the girlfriend. And the court uses a fraudulent conveyance. This case went up to the Supreme Court of Maryland. And then 17 years later, we have another case that also looks at a revocable trust, in which case the court was reluctant to bring the property back in. And we have no bright line rule. What happened in Chacroun was that the court came up with a laundry list of factors that should be used, and then those factors got incorporated into the elective share reform, which is Maryland's new elective share bill that looks at a very complicated formula for decedents dying after October 1, 2020. The calculation is cumbersome. The calculation would never be included on any exam or final. Most practitioners don't even understand it. It is causing a ton of litigation in the orphans court now, and we'll walk through an overview. But the law is so complicated. You'd have to have the bill in front of you to be able to make a calculation.